Okay. What other preparations can you make for your care when your health declines? So.
Well, I have a little soapbox I stand on about this. The most important thing that you can do is to make your wishes known to your family. And even with these documents, they don't cover everything. We can't predict. And so I think that what I advise my clients is to have these discussions about your values and about how you feel about being disabled and in bed. For example, if you have a stroke or you get hit by a car or something like that, you know, how much cognition are you willing to live your life with? Because the family may be called upon to make that kind of a decision, and there may be disagreements in the family about how long you can live or whether you will regain cognition. There may be disagreements among the doctors. So knowing your values and how you feel about it is the single most important thing that you can do with your family, assuming, of course, I'm assuming for this answer, that the agent is a family member. Your agent may be a private professional person, or it may be a friend, or your CPA or a lawyer. Well, not your lawyer, usually they can't do that. But so you want to make sure that whoever's going to make those decisions for you understands completely how you feel. And that's a hard discussion to have. The other thing is, of course, is to do these documents, I think. And you also might want to let your family know what your preferences are in the event that you're demented or incapacitated for a chronic period of time, a long time before you die. And so you want to talk about where you want to live. Do you want to live at home? That kind of thing. And I would highly recommend that you put this in writing, even if you haven't done a power of attorney. Sit down and write it out on your own hand and sign it, because those written documentations are binding on courts of law. So if you don't do this other document, you'll have something that you pass along to your family or your agents or friends.
Yeah. So we don't think that people need this type of guidance, but they really do. And there is the thing too, so, you know, I've worked with you in a situation where I was a trustee and conservator of the person in the estate, and, you know, it's quite a burden to take on, and making really decisions, life and death types of decisions. And so for me, in that capacity, it was very important to me to talk to the family about this and to have, you know, what I hoped was going to be agreement about what I was going to do. And I will say, I felt I was very fortunate in the case that that the family members said, you know, do what you think is right, sort of thing. That, you know, that we're going to support you in the decisions that you make related to this. And so that made it so much nicer for that particular situation. But there's no guarantees that that's going to happen.
Well, you bring up a very good point, Michael. I recall that, and you did a very fine job. And that was a situation where the family members were all caring, but there were perhaps disagreements among them about what decisions to make. And so the person that you were the agent for made a decision to have you. You weren't her son. You were a related family member, but you were her son, and everyone in the family trusted you. And that's a very important thing, to make sure that you pick an agent for that purpose that you completely trust and that the other people around you trust. I've had occasion to have clients tell me, well, my children will all fight if I don't name them all. And so they want to name co-agents.
Yeah, and that's
exactly the reason not to name any of your children, and to look outside of your children as a group, because they frequently will feel jealous or they might not trust each other. Fortunately, when we sometimes see the worst of people, but fortunately that's not true in most cases.
Right.
But you must consider in choosing the agent.
Yeah, you have to be alert for these relationships and conflicts between your kids. And if you put two children that can't get along as trustees or whatever, you're just asking for trouble. And then, sometimes decisions need to be made quickly. And so if you put them in that position, that decision may not be able to be made so quickly. Like you said, then you have to go for direction from a court, and that can take a lot more time.
Right. I think people, I think their intentions are good. They are trying to force this group of people to consider and work with each other. And you can certainly put a provision in your document that says that whoever you name has to discuss it with the children, but a person needs to make the decision. And if there's an inability to make a decision, what it really does is make your document ineffective. It completely freezes the decision-making ability because there's a stalemate, and so you have no document. So yeah, and people, that's what people don't realize. It's not a negotiation kind of situation.
Right.
Yeah.
Okay, well, let's talk about some advantages and disadvantages relating to health care for a durable power of attorney, a conservatorship, and a living trust. So we've got these different types of documents that we can work with, and a lot of people don't understand what the differences are, and particularly we have a big selling job that's going on related to living trusts. There can be some advantages to them. Why don't you talk about that for a few minutes?
Well, let me say, we've talked a good bit about powers of attorney and advanced healthcare directives, and I emphasize that they're voluntary. And sometimes what happens is that a person will get angry at the person who's the agent, or maybe they're demented, so they're delusional, and they decide that they're going to fire the agent, or they're going to object to all the treatment, revoke their power of attorney. And if that happens, it doesn't matter that you wrote it, and this is not the fault of anyone. Sometimes this is just part of the illness that it happens. Then the only alternative you have to impose someone else's decision-making over the person is a conservatorship. And so the intention to do a power of attorney is to prevent having to go to court. But sometimes, don't feel bad, this just happens. And other people who don't execute them, then you'd have to go to court. So the conservator then is appointed by the court, and they have power to make those decisions as long as the conservatee doesn't object. If the conservatee objects, then there's another order that has to be added to the conservatorship, which is medical decision-making powers. And we call them exclusive medical decision-making powers, because it means that the conservator, who's kind of like the agent, they're taking care of what we call the conservatee, who's the ill person. The conservator then can make the decisions instead of the ill person. If you go back to the power of attorney for health care, if you execute a power of attorney for health care, you continue to be able to make your own medical decisions. The only time the healthcare agent would be called upon is if you can't.
Yes.
Or to help you if you want. But in the situation where the conservator is appointed and they have this special order added, then the conservator is the only one who can make the decision. It's sort of like a parent for a child. The child can't make their medical decisions. So that's important to know, that it's a two-step process, and that the conservatorship, even without that, has medical powers, but in compliance with the person's wishes. And having said all that, even if your conservator had exclusive medical decision-making powers, they have to abide by the wishes of the conservatee. So let's say that you did not want tube feeding, and the conservator wanted tube feeding. The conservatorship is not an opportunity for you to impose your values on this person. The law requires that you honor their values, even though you're the only one who can decide. Now, the living trust doesn't usually have healthcare powers in it, but I've seen that. Sometimes people will just add a paragraph or a whole section about it, and it's a writing with instructions, and under California law that can be binding on the person who's going to make a decision. And in the absence of